The Companies Act does not talk about LLP Act or this does not talk about the entity structures merger. So you cannot merge an LLP into a company. You can't merge a company into an LLP. These type of mergers are not possible. Between two LLPs are permissible, between two companies are permissible, but inter-firm mergers are not possible, conversions are possible. So if you are proposing that an LLP should get merged into a company, then you have to first convert an LLP into a company, and then after converting it to a company, then you can do the merger, with effect from the date from which the conversion takes place. The firm into LLP. When a firm gets converted into LLP, there is nothing in the law which talks about that it's a tax neutral transaction. Effectively, there could be a tax liability which can happen. And what happens? When a partners hold the shares, asset, it's an entity partnership firm. When it gets transferred under the common law, it amounts to a transfer. If you read Rule 8 of the second schedule, which deals with the conversion, it talks about that intimation to be given to the authorities where the properties are registered. You need to give an intimation. So there is a transfer which takes place as an entity, and legally it was held by the partners for and on behalf of partnership firm, and it was a partnership property under Section 14, which becomes a property of the LLP under Section 4 of the LLP Act. So that is what there is a statutory vesting takes place, and in view thereof, there could be a transfer. However, there are n number of decisions. This transfer is similar to what we used to popularly call it as Part 9 conversion under the Companies Act 1956, where a partnership firm was getting itself registered as a company. They say that for a transfer, there has to be an inter-divorce transfer, for a normal transfer. Inter-divorce meaning between two existing persons. Now, existing person could be an artificial person, two companies, etc. In case where then an firm gets converted into an LLP, at one point in time, both do not exist simultaneously. As soon as the LLP comes into existence, the firm is dissolved. And when the firm comes into firm is there, LLP is not there. So since not for a second, both were existing at the same time, there cannot be a transfer. That was what was Part 9 conversions took place in case of the various decisions that we have referred to. That is Texpin Engineering, etc., Bombay High Court, that says that it is not a transfer and therefore it would not amount to be taxable. But at the same time, there is another transfer which takes place, that the share of a partner in a partnership firm gets substituted by his share in the LLP, which is a new entity. So that also amounts to a transfer. He ceases to be a partner in a partnership firm and he becomes a partner in an LLP in consideration of ceasing, and that also can amount to a transfer. Ideally, they should provide under the Income Tax Act that there is a tax neutrality in respect of when a partnership firm gets converted into an LLP. However, how they have tried to achieve this is that there is the Finance Number 2 Act 2009, which talked about the Conversion and LLP Act when it was notified. Circular number 5 of 2010, dated 3rd June 2010, it talks about that when there is a conversion from a general partnership to LLP, shall have no tax implication if rights and obligations of the partners remain same after conversion. So it says very clearly, so there is a circular which does not have any authority under law. They have said that it could be tax neutral transaction. That's what provided, and a condition which the board member, when he wrote for the Babu Jami Usne Likha, at that time he thought that this is a condition which I want to. There is no parliamentary backing, there is no legal backing, but there is a provision. So I am doing the fallback is available, that is the Texpin Engineering decisions, etc. That is the fallback which is available. But otherwise than that, this is one thing which is possible to be converted and done in respect of that. So you have a next speaker who is there, and he has already given me a warning that I need to finish off as fast as possible. So, similarly, benefit in the section 80IA, 80IB, 80IC, 10A, which are all benefits which are attached. So, for example, a firm which is there existing, and that firm gets converted into LLP. The decisions which say that there are old circulars, and that circular it says very clearly that when there is a benefit which is attached to an undertaking, and if that undertaking is transferred, the benefits which are attached to that undertaking would automatically migrate to the new undertaking. So when there was a conversion or there was a merger, etc., of a company with another undertaking which was entitled, those benefits would automatically migrate to the company for the balance period it would entitle to get the reduction. These are some decisions, Chetak Enterprise and TechBook and Kumaran Systems. These are the decisions which support a view that when a partnership comes for a balance period, it would still continue to get it. The question that would arise is whether AMT, which is available to a partnership firm, Say, for example, a partnership firm was liable for an AMT, or it has got an accumulated credit of, say, for example, 1 crore rupees when a partnership, normal partnership, gets converted into an LLP, whether that would migrate into a new entity or not. And for that, there are, in fact, what it says is that entire assets of the partnership firm and entire liability of a partnership firm by way of a statutory provision gets vested into the LLP on it being registered as an LLP. Right to receive a credit of AMT under the Income Tax Act is also a right under the Income Tax Act. It's a property. It's a property that also gets vested into the new company, new entity, and therefore the right to get this also would get transferred, though there being no provision. And let me tell you that there is a decision to which I have made a reference, which is 314 ITR 137, which is Jindal Exports, which predominantly deals with transfer of MAT credit, MAT credit, or merger of one company to another. Income Tax Act does not provide for transfer of MAT credit from X company to Y company. But this decision says that when there is a transfer in the statutory vesting under section 391 and 394 of the Companies Act, 394 says that when the merger is passed, the entire, all the assets and liabilities of the company gets vested into the transferor company, gets become the assets and liabilities of the transferee company. So in view of that, the entire gets transferred, and the new company would be entitled to the benefits of the MAT. Taking the same analogy, we can say that when the partnership firm gets converted into an LLP, it would be entitled to get the benefit of the AMT which it has got. So this is a circular to which I have already made a reference. So this is one thing which we can think of. So I think you can reasonably say Namita Javeri had decision had said that a circular of the department are binding on the department, including especially beneficial circulars. So there is a circular which is the department. So therefore, if you convert a partnership into an LLP, there would not be any tax liability on account of any transfers which would take place. Firm to LLP stamp duty. The provisions are fairly similar to Part 9 conversion, and where there is a Valli Pattabhirao decision, which is an old decision. I have not come across any decision thereafter. I have done so much of research, but this decision is holding ground since many years. It says that whenever there is a statutory vesting which takes place, the Articles of Association does provide, and there is a statutory vesting. If you have paid the enough necessary stamp duty under the Companies Act for incorporating a company, there is no other stamp duty which is payable, because that is the instrument under which that is transferred, and there is a specified stamp duty for that instrument, and in view thereof, there is no additional stamp duty payable in respect of that. They have also gone into the aspect of the transfer which is taking place. It is not an inter-divorce transfer. So many complex issues they have discussed, but they have said that no stamp duty is payable in case where the partnership firm gets registered as a company under Part 9 of the Company. I need to bring about a caveat in this. The caveat is that there is a slight difference between the provisions of the Companies Act for the purpose of conversion under Part 9 and the LLP Act, which talks about it. And for that, I want to point out Rule 8 of Second Schedule, which talks about conversion of a partnership firm into an LLP. And similar provisions are there in respect of conversion of an LLP into a company and company into LLP. So all these things, no, not company, conversion of a company into LLP, that the Schedule 3 and Schedule 4 provides exactly the same provision. And it says that in case if the property, which is subject matter of this statutory vesting, if it is registered with an authority, then the company will take necessary, or the firm would take necessary step for giving intimation to the respective authorities for recording entering the name of the partnership firm in this. So therefore, one of the arguments which was taken in case of Valladolid is that there is no document which is necessary. So if you have to pay the stamp duty, on what document you pay, right? Because there is no transfer. Transfer takes place because of the Companies Act, and there is a statutory vesting. Here, it does take place, but there is a requirement of giving an intimation. There is an additional provision which has been created. Whether the state government can take a view that per se the transfer does not take place, the statutory vesting takes place, but there is a requirement for an instrument to be introduced in writing, and that instrument amounts to a conveyance, and therefore I would be liable to pay. I hold a view strongly, the same as what Ashok holds. In fact, we had a discussion in the morning. He holds a view, and very rightly so, that no stamp duty would be payable, right? I still hold that view, but you need to be careful when you do the planning. You need to advise your client that there is a possibility that there is a distinction. It's not the same as what is happening in respect of Part 9, and therefore we need to definitely keep it in mind that this Rule 8, which is different, not yet come up for any interpretation, and that's the reason why we need to be careful in respect of this provision, which is required to be kept in mind. From an LLP to a firm, there is no provision under the Income Tax Act, under the LLP Act, for the purpose of conversion of an LLP into a firm. There is a provision that how a firm can be converted into LLP. The converse is not possible, at least not provided for under the law. So therefore, it would only amount to a dissolution of an LLP. If it amounts to a dissolution of LLP by following the provisions of LLP Act, in that case, whatever are the situations which are related to Section 45(4) would apply, and therefore you need to be careful in respect of how do you plan in respect of that. There is no provision of statutory vesting, so therefore normally it would be exposed to whatever are the normal tax liabilities which are there under the normal provisions. Companies to an LLP. Now when a company gets converted into LLP, there are two types of transfers which can take place. One which complies with the provisions of Section 47(13)(b), and those which do not comply. No, and when I say that, I'm reminded of a very famous thing which Mr. Palkiwala used to say about Parsis. And he used to say there are two types of Parsis. No, sorry, Mansi used to say about his conversation with Mr. Palkiwala. So, Mansi used to say that, when I talked to Palkiwala, he said there are two types of Parsis. Those who work in central bank and those who don't. So Mansi said that okay. So therefore he said that okay. So which means I feel that there are those who work in central bank and those who don't, mean those who work somewhere else. He said no. There are two types of Parsis. Those who work in central bank and those who don't, means they don't work at all. So it's like this. Then when we talk about, there are two types of conversions which are possible from an LLP, from a company to an LLP. One which complies with Section 47(3)(b) and those who do not. So we will deal with the tax liability in respect of one. Section 47(3)(b) talks about that it could be completely tax neutral transaction. No tax liability arising in respect of in the hands of the partners or in the hands of the LLP when the property gets transferred from the company to the LLP. So and what are the conditions? I will quickly run through this condition, but I will deal with each condition which is important and what are the changes which are there in Section 47(3)(b) and the conditions in respect of 47(3)(13) which deals with the conversion of a firm to a company. Right, so I will deal with that quickly so that things become a little clear. All the assets liability of the company before conversion become assets and liability. That's one condition. Just to point out, it does not talk about all the assets and liabilities of the company related to the business. You remember in case when we talk about 47(13), when a conversion of a partnership firm into a company, it talks about all the assets and the partnership firm related to the business. So for example, theoretically there is a residential house belonging to the owner. If by mistake it is still continuing in the partnership firm, if I decide not to include that as a part of a transfer, it would not be violative of Section 47(13). But in case of a company, it would be violative of 47(13). So you need to ensure that all the assets and liabilities of the firm of the company, whether related to the business or not, it will have to be converted into an LLP or become. All the shareholders before conversion become the partners in their interstate shareholding ratio. Right? So whatever was their shareholding ratio in the company would become partners with their profit sharing ratio in the same proportion. It's immediately before conversion, right? So anything which has happened 5 days before conversion is not affected, right? Anything which happens 15 days before conversion is not affected. Immediately before conversion, whatever is the share, that will have to be calculated into mind. Remember again another distinction, it is the shareholding portion which is proportion which is required, no distinction which is made between the preference shares and the equity shares. It does not make distinction between the partly paid shares and fully paid shares. Right? So all these things are required to be kept into mind before you do the conversion. Shareholders do not receive any consideration or benefit directly or indirectly other than by way of a share of profit or in the capital contribution. So if I've got 1 crore of capital, 1 crore of capital will be credited in my account, nothing else can be given to me. Aggregate profit sharing ratio, this is very important. Aggregate profit sharing ratio of shareholders shall not reduce to less than 50% at any time during 5 years from the date of conversion. Right? So for 5 years, at least 50% share has to be with the same persons. There could be internal changes, but the 50% or more has to be with the same set of persons. I'll come to some planning stage which is possible in this particular. Total sales and turnover and gross receipts should not exceed 60 lakhs in any of the 3 years immediately preceding the year in which the conversion takes place. So in the 3 years down the line, you say your turnover was more than 60 lakhs, you are not eligible. So you have to ensure that the turnover is less than 60 lakhs. Again, possibility of planning. No direct or indirect payments to partners out of accounted accumulated profits for 3 years. Accumulated profit means the profits as per the books of accounts. Section 222E says it does not talk about accumulated profit which is hidden in the assets. It talks about accumulated profits as per books of accounts. That is very important. So if I have an asset which is appreciated from 1 crore to 5 crores but not sold, it's still lying in the books at 1 crore rupees. If I convert it, then it does not mean that I can't even disclose, I can't distribute 1 crore, but I can always distribute balance 4 crores rupees which is hidden on the date of conversion. Right? So that's what is possible. Now let me go to each of the items and give you something which is possible, what is the interpretation. Aggregate profit sharing ratio of the shareholders immediately prior to such conversion should remain for 50% for 5 years. Now what happens that, let's take a situation that before I convert into an LLP, and it does not talk about beneficial shareholding, right? It talks only about the shareholding per se. Section 79 talks about beneficial shareholding. So even if there is any change in the beneficial shareholding, Section 79 could be hit. Here it does not talk about beneficial shareholding. So let's take a situation that before I have an intention that okay, I want to convert into a company and I want to sell off the whole company. And that's what is my desire. But I still want to take advantage of section 47(3)(b). So what I do is, I will first take 51%. I will put a company into this. So 51% shareholder would be a company. And then I transfer it to new person. I convert it into a company. LLP I convert. So LLP would get converted into a company would have 51% would be a person who would be the shareholder in the, an LLP would be a shareholder in a company, and that would get converted into an LLP. So therefore, and then what I would do is, I will change the partners of the LLP, and I will change balance 49%, I will say. In such a situation, there would not be any capital gain arising on account of conversion from an LLP from a company to an LLP. So let's take a situation that you have a company, you first admit a company, another company having 51% shares into that company. So the shareholding of the company is 51% in the new company and 49% are old shareholders. Then you convert that LLP company into an LLP. And what you do is, when you transfer two things: the shares of the company which holds 51% shares and balance 49% shares which are held by the original shareholders. So when you transfer these two things, what advantage that you get that there is no change in the shareholding, and therefore this transfer also becomes tax neutral. Now this may not give benefit to the shareholders because shareholders the cost of acquisition is the same, but it would certainly give the benefit of the assets which are hidden, and the company may not be liable for paying capital gain tax in respect of the transfer which took place from the company to the LLP. So that's one thing which is possible if you do the restructuring immediately prior to the transfer. The sales turnover and gross receipts, what is covered by it. Fortunately, there is a circular of the tax department, which circular number 1 of 6/4/2011, which says that the profit, the turnover means it talks about only that are taxable under the profits and gains from business or profession. So dividend income is out, the rental income is out, the capital gains are out. So all those provisions are out. Only those which are covered under the provisions of section 28 would be chargeable to be considered for the purpose of profits and gains from, or for the purpose of. So for example, there is theoretically a company which is a real estate company, which has got 5 crores of rupees of real estate income which is happening as a rentals. It would still be entitled to claim the benefit of conversion. Let's talk about another case where you have manufacturing concern which has got 5 crores of turnover. You still want to convert to an LLP. How do you do that? Now, again planning. I don't take risk of litigation in this. The risk of litigation is taken by the client who does it and the chartered accountants who advise. I don't. Now, let's theoretically say a situation that, say for example, I have got a company which is A Limited, which has got 5 crores of turnover. I have desperate desire to convert into an LLP immediately. Now, what I do is, in the group there is another company which is a docile company incorporated for 5 years, does no turnover. practically no turnover, a turnover of 10 lakhs or 15 lakhs or 20 lakhs. Now if I merge this manufacturing concern into this company, there's a new company. There's the old company which is a docile company. Now in that dormant company, when I merge this company, and after the merger, if I convert this dormant company, which is now the manufacturing company, how would the provisions apply? Undoubtedly, the year in which the conversion takes place, my turnover would be more than 60 lakhs. Or what is the limit? 60 lakhs. Undoubtedly. But what is to be seen is 3 years immediately preceding the year in which the conversion is to take place. So if I do the merger and in the same year if I do the conversion, it is easily possible to contend that immediately so I comply with this condition without any difficulty. So if you look at it, if you really want to convert a company which only does not meet the turnover criteria, then it is possible that if there is a merger which takes place, then it is possible to probably get out of this provision. I did talk about the no payment of out of accumulated balance, which I said that only talked about accumulated balance as per the books of accounts. In case if you do the change in structure, section 72A subsection 6, when the company is converted to an LLP, section 72A subsection 6 provides that the entire losses and accumulated depreciation of the company would get migrated to the company and it would continue for another period of 8 years for which the benefit would be available. So in case if a company which has got an expiring losses, if you convert it to LLP, you will get a fresh lease of 8 years for the purpose of setting it off for a period of next 8 years. The MAT credit cannot be, because MAT is on a different footing, AMT on a different footing, so whatever the MAT credit which is accumulated of a company, that would be completely lost. Section 115JAA subsection 7 also provides that when a company is converted into an LLP, it would lose all the benefits of accumulated credit for MAT, which will be applicable. Depreciation and WDV would be as per expression 2C of 43C6, which says that WDV would be the same as the WDV of the company if it had not converted. The depreciation would be allocated between pre-conversion and post-conversion period on a straight line basis. Let's say, for example, for 40% of the days if the company was there, and after for 60% of the LLP is there, you can calculate the whole depreciation as if the conversion has not taken place, and 40% of that depreciation was available to the company and 60% to the LLP. That is what the extension provides for. Only thing is, it says only about that year. It does not talk about subsequent period, but I am not going into that controversy. I have given you enough amount on which you can do the litigation. I don't think so that I need to give you anything more. Conditions are, in case the conditions are violated, say for example the change in shareholding takes place or the assets are distributed or something of that sort, and that those violations take place. In that situation, the year into the violation takes place, the amount becomes chargeable to tax in the hands of the LLP. And the partners, in case the partner share is not chargeable to tax, the partners would be paying tax in respect of their capital gains, which has been exempted because of the provisions of section 47(13) of the Income Tax Act. 13B of the Income Tax Act. Right? So that's what. So in the conditions violation, it is that year in which it could be taxable. It could not relate back to the year in which the exemption was actually granted in section 47. In case of a non-exempt transfers, say for example, there is a conversion which takes place from a company to an LLP. Company to LLP has all the characteristics of Part 9 conversion, and therefore nothing would actually be chargeable to tax, especially the company is concerned, because the company is transferring. There are primarily two arguments available to a company. First argument, that there is no transfer. It's a statutory vesting, and for transfer you need two persons existing at the same time. When a company gets converted into LLP, there is not even a second at which both parties coexist, and therefore transfer is impossible. So that's one. Second is, a consideration has to flow from a transferor to the transferee. Sorry, from the transferee to the transferor. Right? The consideration has to flow. Here there is no consideration. The company does not receive anything. Company gets dissolved. The consideration, if at all there is a consideration, it flows to the shareholders. So on these two grounds, there is no capital gains tax which is payable in case by the company when a conversion takes place from an LLP to the company. From a company to the LLP. First. Now let's talk about this another transfer which takes place. I as a shareholder was holding shares in the company. I am talking about non-exempt transfers, right? I am not talking about exempt transfers. I am holding shares in the company. When I am holding shares in the company, that shares get extinguished, and what I get is the value. I get a share in the LLP. Right? So this is what happens. Now, if you recall, there used to be a range of decisions starting from or ending with Grace College, which changed the whole thing. But there was Leo Machado, and then there was the Garden Silk Mills, and these were the decisions which says. And as you recall, section 2, subsection 47 deals with the definition of transfer, which also talks about extinguishment of a rights therein. Is also considered to be a transfer. While interpreting this 47, 2 subsection 47, they say that a transfer envisages that pre and post transfer the asset should remain into existence. But if the asset itself gets destroyed or asset itself gets extinguished, in that situation it does not amount to a transfer under section 2 subsection 47, and therefore insurance proceeds received on account of sinking of a ship or the on account of extinguishment of shares, these things would not result into any capital gains. That was the line of argument which was taken. Matter came up in Grace College. There is 248 ITR 323. My first article published in BCA journal was Grace College decision of the High Court. That was the first decision. What are the implications of Grace College? That was my first decision, first article which was published in BCAJ. Unfortunately, that is the reason I am very fondly loving this particular decision. That has been reversed. The High Court, the Supreme Court says that, look, even if the asset gets destroyed, still it could amount to an extinguishment, and if it is an extinguishment, it amounts to a transfer. There is another decision which has been given in respect of redemption of shares by Anarkali Sarabhai, where also they have said that a redemption of shares would amount to a transfer, and any proceeds or any appreciation which you have received or any surplus which you have realized on account of redemption of shares would amount to a transfer, and it would be chargeable to tax. So in view of that, first, the extinguishment of shares in a company on account of conversion into an LLP would amount to a transfer. So that condition is one thing which you should always keep in mind. The second is what is the consideration received, because they have received the share in profit, and Sunil Siddharthi says that the share in profit in the partnership firm or amount does not reflect the consideration. Section 45(3) does not protect it, or section because there is no transfer of an asset. So none of these provisions apply. So therefore, whether it can be considered. Now that is where I would try to bring about provisions of section 50D. Now 50D says where the consideration cannot be ascertained or it is not ascertainable. In such a situation, fair market value of the share to be considered would be the fair market value of the share in the profit to be considered. This and therefore, in case of a non-2 subsection 47B transfer, there is a real serious issue in respect of the shareholders getting taxed in respect of extinguishment of their shares by virtue of reading of this. So, what is applicable in case of other conversions? This would be a very dangerous provision. So even for the sake of litigation also, it may not be advisable to go in for such type of conversions. Unless you are trying to fit yourself in some other way for the purpose of ensuring that you fit into some sort of a conversion. Otherwise, there is a serious risk in respect of capital gains tax chargeable in respect of such type of situations. Right? So just look at section 50D and probably I hope that you will also come to the same conclusions as I have done, because all the earlier lines of argument which are there, none of them would be applicable with respect to section 50D, especially the protection of Sunil Siddharthi would not be available. Sunil Siddharthi or Karthikeya Sarabhai, this would not be applicable. Conversion from an LLP to the company, section 47(13) talks about a firm, conversion of a firm into a company. The same provisions would apply to an LLP also, everything would apply. There has to be conversion of a conversion as a going concern is a requirement. You cannot convert a debt concern or an asset concern only. It has to be a going concern, and going concern in entire business is required to be transferred. Similarly, Part 9 conversion, same principles would apply in case it is the Part 9, then the no stamp duty which is payable. I think I am not dealing into that because it is predominantly similar to the partnership form. There's no mergers and demergers of elements. Do I have time? 10 minutes. Okay. Now, section 60 to 62, section 60 to section 62. 2 is coming many times. So, this provides for an entire provision where the two LLPs can be merged. These provisions are very similar to section 391, section 392 and section 394 of the Companies Act. So, these are the two sections which are bodily lifted from Companies Act to the provisions of the LLP Act. And therefore, the courts have power to do any sort of a compromise, any sort of a demerger. So, there is no power under Income Tax Companies Act for doing a merger, right? There is a power, what we call it as a scheme of compromise and arrangement with the shareholders, or a scheme of compromise and arrangement with the creditors. Now, under a scheme, the High Court has the power to order for an amalgamation or order for transfer of an asset from a transfer company to a transferee company. So, all the mergers and demergers that we talk about is actually a scheme of arrangement between either the shareholder or the creditors, or both. Similar provisions are contained under the LLP Act for the purpose of doing. So, theoretically, you can have a merger of two LLPs, or you can have a demerger of more than one undertaking which an unit which an LLP has into another LLP. That is all permissible under the law. I still have to remember that you give me time, but I have a flight to catch at 4 o'clock. So I just forgot that in my enthusiasm to speak, I forgot that. But I'll just finish off in next 4 or 5 minutes. So, when a merger takes place, what is the tax implication which could happen? When a merger takes place, there are two things which happen. One is that there is a statutory vesting which takes place in case of a share of profit of a firm, assets of A Limited, A company to A LLP to B LLP. That's the transfer which takes place. But that transfer is also not chargeable to tax, though it is a transfer under the Income Tax Act. It is not chargeable to tax because the second condition, as I told you, for a transfer to be chargeable to capital gains tax, there are two conditions which are to be satisfied. One, there has to be a transfer, and second, the consideration should flow from the transferee to the transferor. Here, the consideration goes to the shareholders because the shareholders get the share on account of transfer. Consideration does not pass, so therefore, no capital gains liability onto the LLPs when the transfer takes place on merger. In respect of shareholders or in respect of the partners, whether there is a merger would entail. Now, what happens that I had a share in an X partnership firm or X LLP, it gets substituted by a share in the another LLP. That could also amount to actually a transfer because I extinguish my share in a firm and I gain a share in the another partnership. The cost of acquisition, the consideration by virtue of section 50D is ascertainable or it is fair market value of those capital. But what happens to the cost of acquisition? Because cost of acquisition is still not ascertainable because my cost of acquisition of a transferring LLP cannot be ascertained. Sunil Siddharthi says that my share of profit or my amount credited in my books is not the cost of acquisition, it's not the fair market, it's not the full value of consideration. And in view thereof, it is possible to contend that when the merger takes place between the two partnership firms, neither the partners nor the partnership firm, either of them would get tax in their own hands. So that's what is the view which I take in respect of merger, and that's what is the view which we have already taken, and I think it has been supported by way of a few opinions which we have taken in respect of this. So I'll move forward significantly. Okay. Similarly, when we talk about a demerger, in demerger, what happens that I am a partner in a partnership firm. In an LLP, one of the undertaking of an LLP under a scheme which is formed under section 60 to 62 of the LLP Act, one of the undertaking gets transferred to another LLP, and I get, on account of this transfer, I as a shareholder, I as a partner of an LLP, I get a share in another LLP. Now, whether that would amount to a transfer. Again, two levels of transfer that we talk about, two types of taxability. One is taxability of an LLP. At an LLP level, it does not amount to a transfer chargeable to capital gains tax because it is a transfer. But though it is a transfer, it would not be chargeable to tax because there is no consideration received by the LLP. Since there is no consideration received or receivable by an LLP, there is no capital gains chargeable in the hands of the LLP, which is transferring a undertaking under a demerger. It's not a sale, but it's a demerger, right? In demerger, the company, transferring company does not get anything, or transferring LLP does not get anything. It is the shareholders who gain the share in the new entity. So far as the shareholders are concerned, they get a share in the, but they are not transferring anything. So they are not transferring. What they have got the share in this firm which remains the same. I have 20% share in an X partnership firm, remains an X partner in LLP, it remains the same. So I don't transfer anything, though I receive a consideration, I don't transfer it. And in view of that, even in case of a demerger, it is possible to contend that there is no tax liability which would arise in the hands of either the partnership firm or in the LLP, or in case of a partner of an LLP. Either of the two cases, there would not be any capital gains tax liability which would arise, provided it is done under section 60 to 62, which talks about statutory vesting of the property in the hands of the new LLP. So this would be my view in respect of mergers and demergers of LLP. Okay. I did mention, in respect of international tax, it can have serious implication. Very, very different entity characterization could be an issue in respect of LLP. And this would be very important when you are dealing with the foreign consultants. It is very essential that we need to tell them about the tax structures here. The major difference which happens in respect of an Indian LLP and an LLP which is outside the country, like say for example UK and US, if you especially talk about LPs, they call it. In case of those LPs, they are tax transparent entities, meaning that they don't pay any tax. The taxes are paid by the partners. So if an LLP has got 1 crore of income, it gets transferred to partners, let's say for example 10 lakhs each to 10 partners. It is the partners who pay tax, the LLP does not pay any tax. It is not liable to tax sharing. And that's the concept in the land. India, there is a different concept. LLP pays full tax, the partners don't pay. India is now got a very wide treaty network, and where there is a definition of an entity. It does not follow the income tax definition of an entity. Right? It follows its own definition. It says, and it defines individual. What is an individual? It talks about company. And when it talks about company, what it talks about, that a company means a body corporate. Right? A body corporate or any other entity which is treated as a body corporate or as a company under the tax laws. So since it's a body corporate, it would be classified as a company under the DTAA. Now why it is important that it would be treated? Because the DTAA treats differently the share of profit and it deals differently the dividends. The credit which is available to the other entity on the other side is different in case of dividend and in case of share of profit. So it becomes very essential that we need to see as to how it could be characterized in that country and how the person who is making an investment into an LLP in India would get credit. Now let's take a situation in case of the US. Now US has got a unilateral system. Of course India-US treaty also provides for, and India-US has got a treaty unilateral provisions for giving an underlying tax credit. Normally, say for example, if dividend is paid and there is 10% deduction of tax at source on those dividends, then the receiving entity would get that 10% reduction. But in case, say for example, a similar provision was there and an American entity had made an investment beyond a threshold which is available 10% to 25%, if that is an investment which they have done, in such a situation, the US entity would not only get tax of this 10% tax which is deducted, but even the tax which is paid on the profits out of which the dividend is paid. So for example, there was 1 crore of profit on which 30% tax is paid by the company, 70 lakhs left, and 70 lakhs is distributed, then they will get credit not only for TDS which is done, but they will also get credit for this 30 lakhs tax which is paid by the company, which is out of which the profits are distributed. So that is the concept. If you characterize this as a company, to US entity, then it would be entitled to this underlying tax credit. If you do not characterize this as an entity which is a company, then these underlying the taxes which are paid by the LLP may not be available there. So that is what it has become very important. There was a recent issue which had come up in respect of UK LLPs, how it would be treated. See, a definition of a resident that we talk about under the DTAAs is a person who is liable to tax in that state, right? That is what is the definition. As you have seen that in UAE, individuals, whether they are considered to be resident, though they are staying 182 days or 100 days, or whatever number of days in UAE, whether they would be considered as one decision, etc. They said they are not, individuals do not pay any tax, they are not liable to tax in UAE at all. So it was said that they would not be considered to be resident and therefore they would not be entitled to DTAA benefits. Similar issues came up in respect of LLPs. Of, say, for example, UK, they don't pay any tax. USA, they don't pay any tax. The question that arose whether they would be treated as a resident of that country, and therefore would they be entitled to take the benefit of KT? Because for taking benefit of KT, a person has to be a resident of either of the contracting states. If they are not the resident of either of the contracting state, that was a difficulty. So UK treaty, USA treaty did provide for an LP situation, when they said that in case if the persons who are the recipient of income from that partnership, if they are residents of USA, in that case their LLP also would be treated as a resident. They have made a similar amendment recently in the UK entity, to which I have made a reference to this earlier. I think we do not have a lot of time in respect of this, but I think some of the last slides I have mentioned in respect of this part. So thank you very much for giving me a very patient listening in respect of this topic, which is a new emerging topic. Thank you very much. Yeah, please.